Earlier this week, a senator argued that, or stated that, it's not the U.S. Supreme Court that's supposed to fix this country culturally, economically, socially, spiritually. Courts should not try to fix problems that are within the province of the U.S. Congress, even if the U.S. Congress does not have the courage to address those problems. Our courts were not meant to decide these kinds of issues. That logic would mean that African Americans wouldn't be able to attend integrated schools, buy a home previously owned by a white person, or lodge at certain hotels. In many cases, the High Court has acted when Congress had neither the courage nor the will to act. For nearly 8 decades, African Americans have fought to secure historic legal victories that have significantly bent the moral arc of the universe towards justice, even at times when progress felt incremental. Nonetheless, we know that reversing meaningful progress for decades to come would be profoundly devastating and an affront to all who courageously fought on the front lines, some of whom I currently represent as chair of the Congressional Black Caucus. President Trump has seized on this opportunity to pack the court by selecting judicial nominees who lack pragmatism and are often strikingly unqualified and proven intolerant bigots. We're in the midst of a fundamental shift towards nominees that embrace ideology at the fringes of mainstream legal thought. The current administration has nominated, and with the help of Senate Republicans, have confirmed a range of nominees whose confirmation hearings portend a precarious legal fate for communities of color moving forward. Mr. Kavanaugh's confirmation will fortify a generation of destructive conservative ideology at a time when several historically significant legal challenges will come before the High Court. As members of the CBC, we cannot overstate what is at stake for African Americans and communities of color across the nation. Judge Kavanaugh, who relies heavily on the same textualist reading of the Constitution employed by former Justice Scalia, possesses a conservative judicial record that leads us to believe that voting rights, education, criminal law outcomes will be greatly endangered in the coming years. A careful, in-depth evaluation of his record, which has largely been shrouded in secrecy and withheld from public examination, uncovers writings that illustrate sparse commitment to equal protection under the law. Additionally, Judge Kavanaugh's lack of deference to precedent is staggering and inconsistent with other conservative judges who currently preside on the D.C. Circuit Court with him. A judge who frequently questions key legal precedents represents a grave danger to many legal frameworks that have advanced the African American community. Voting rights. From Ohio to Wisconsin to Georgia, the vestiges of Jim Crow have resurfaced under a new cloak, unchecked and unabated. While these states are no longer conducting literacy tests, the effects of their new policies have been implemented with staggering precision and efficiency. By a 5-4 vote more than 5 years ago, the court struck down Section 4 of the Voting Rights Act of 1965, making Section 5 of the law essentially unworkable. The decision has precipitated a myriad of voter suppression efforts across the country. Most recently, the Randolph County Board of Elections and Registration in Georgia inexplicably considered a proposal calling for the closure of more than 3/4 of the polling locations in the 60% black county, including one location that is 97% African American. Despite the eventual rejection of this ill-fated proposal, the federal government never bothered to intervene and fulfill its statutory obligated responsibilities. Simply put, there is no longer any active federal mechanism dedicated to oversight and safeguarding an individual's constitutionally protected right to vote. As I told you in January of 2017, Jeff Sessions' record on civil rights is questionable and one that shows that he does not care about enforcing civil rights. It is within this context that we have grave concerns about Judge Kavanaugh's opinion in the 2012 case of State of South Carolina versus Holder. In 2011, under the Fully Viable Voting Rights Act of 1965, the Obama administration blocked enforcement of South Carolina's state-issued photo ID law because it affected up to 8% of black South Carolinians. In his ruling to uphold the law, Mr. Kavanaugh claimed it does not have the effects that some expected and some feared. Not only is this statement inexplicably tone deaf, it is also inconsistent with reality. These same real-life consequences reverberate to other elements of everyday life for black families. On criminal justice, Judge Kavanaugh's record on criminal justice is entirely unsatisfactory for a country persistently struggling to hold law enforcement accountable for mass incarceration and police brutality. He has expressed a desire to overturn precedent that protects civilians from officers engaging in activities inconsistent with the Fourth Amendment. He suggested that probable cause standards should be more flexible, which would expose more African Americans to failed policies, police tactics like stop and frisk. Additionally, Judge Kavanaugh's support for narrowing individuals' Miranda rights would hurt people of color who are disproportionately subject to excessive law enforcement engagement in their respective communities. And lastly, affirmative action. Mr. Kavanaugh's record on affirmative action is particularly disturbing and ripe for intense scrutiny. Almost 20 years ago, while in private practice, he wrote that in the future, the Supreme Court would agree that, in the eyes of government, we are just one race. Given the Department of Justice's recent investigation into Harvard University's admission practices, we're deeply troubled by the increased likelihood this will come before the Supreme Court in short order. With that, Mr. Chairman, I will submit the rest of my testimony for the record, but I will just conclude by saying that with the cloud of criminality and lack of transparency, the Congressional Black Caucus, which is 48 members, we represent 78 million Americans. And I just wanted to say for the record, of those 78 million, only 17 million are African American. We represent a vast variety of people, and we represent a collective conscience of this country, black, white, in the spirit of Goodman, Cheney, and Swarner, who gave their life to make this country a more perfect union and to fight for civil rights and to fight for justice. And it is within that spirit that we have grave concerns and oppose the nomination of Justice Kavanaugh. And thank you for your time, and I know I went over.